So let's continue. The roadmap. Yes, I'm excited. So tell us a little bit about what to expect sort of in this journey.
Okay, first of all, this is a really high level roadmap. We're not going to go down all the little highways and byways and get you lost by going down little country roads. We're looking at basically, if you're trying to get to Florida, what are the main highways and what are the routes you're going to go?
Okay.
This is the kind of analogy I'm using for the how high above surface we're looking at the roadmap to figure out what the process is in family court.
Okay.
But it's just saying if you are going to be going into family court, there is a set process you're going to go through. Okay. We're flagging the steps in the process that are set out in the family law rules. We'll talk a little bit about what each step is about, what you need to do for each step.
Yes.
And how they all work together. So does that sound like a game plan?
Sounds good.
Okay. All right. So let's say that you've been in a family law situation, there's been a breakdown of that family relationship, and you decide you cannot work it out by extra court activities such as doing ADR, alternative dispute resolution, or negotiating a settlement agreement or anything else. You and the other side can't come to terms on an agreement for what you want to do. You've decided you need to start a court application. You need to go to court to get an order from a judge because you and your partner, soon to be ex-partner, or already ex-partner, cannot agree on how this family is going to function on a go-forward basis now that you're no longer together. So one of you decides that you have to start an application. So the first step in initiating a court proceeding is the applicant will prepare, serve, and file an application. Those applications are specified forms under the Ontario Court Forms. They're available on the website. It's a Form 8. Depending on what you're actually applying for, what Form 8 variant you're going to use depends on what you're going to be asking for. Then you, again, depending on what you're asking for in your application, there will be other required documents that you also have to complete, serve, and file on the other side. For example, if there's a property claim or a support claim, you're going to have to do a Form 13 financial statement. If there are kids, you're looking at parenting affidavits. That's a 35.1 and a 35.1A parenting affidavit. And usually what happens is when the applicant is creating their application, which is, like I said, a set form, if they are in the Ontario Court of Justice or the Superior Court of Justice Unified Family Court, when they do their application itself, the court will give them actually a first appearance date, which will be set out right on the front of the application that tells the other party, this will be the first time you're going to court. Let's say we're dealing with an originating application. You've never been to court before with your partner. So you complete the application form. You leave the court file number blank. You leave the first appearance date information blank. But you complete all of the other, you fill in all the blanks and you tick off all the boxes and you do everything else you need to do. You sign your application and you date it. Again, depending on what you're asking for, like if it's support, you will also have to do a financial statement. Well, the financial statement is a sworn document. So you would complete your financial statement. And if there are kids involved, you have to do a parenting affidavit. An affidavit is a sworn statement. So you would prepare all your documentation. Then you would take your documentation to, you either do it electronically or you can go to the court office in person. And at the court office, then they will review your documentation. If everything looks okay, they will swear your affidavit and they will take your application. They will give you, and they will fill in or tell you what to put in for what your first appearance date is going to be. They will assign a court file number to it. And it's so that means they have issued the application. So once the application is issued by the court staff, then the issued and sworn documents get served on the other party. Okay, now because your application issued, when the respondent receives that documentation, they do an answer. They're using the same file number. So they don't have to get their answer issued because the court proceeding, the file has already been opened. But they have to do their answer. They have to sign it and date it. If there's any sworn documents, like a financial statement or a parenting affidavit, they have to get those documents sworn. And then once they've got those documents sworn, then they serve the answer with the sworn documents on the other side. And then they file it with the court with an affidavit of service. So now we're going to switch to the other side. So now the respondent has been served with the applicant's documentation. Once the respondent has been served with the documentation, the respondent has 30 days after being served with the application to prepare, serve, and file an answer.
Mhm.
And that prescribed form under the Ontario Court Forms is Form 10. And again, all other required documents, depending on what is claimed. For example, again, if there's a property or support claim, that the respondent will also have to do a financial statement. And if there are kids, the respondent will complete their own parenting affidavits, either a 35.1 or a 35.1A. You don't have to do those affidavits if there's no kids. But again, kids are quite often the whole main reason why parties are getting into trouble trying to figure out what to do on a go-forward basis. Okay, and it is indicated right on the application, and the respondent is told that once the respondent is served with the application, the respondent has 30 days in which to file their answer.
Mhm.
If an answer is not filed with the court within 30 days, so that means the respondent has to do the documentation, serve it on the applicant, and then file it with the court. Then, if that's not done within that 30-day period, then the case can proceed without the respondent having any involvement at all. So what it means is the respondent will be noted in default because he or she has failed to respond to the application within the time set out in the family law rules.
Mhm.
So what that means is that the applicant can then go ahead and get an order without the respondent's involvement and then actually enforce that order against the respondent. Now, it is possible because sometimes people get served and they decide they want a lawyer to help them, and it's taking them a while to get a lawyer to help them with their documentation. So the
Mhm.
respondent can ask the court for an extension of time to prepare, serve, and file materials. But the default deadline is that once you get served with an application, you have 30 days in which to file an answer. If you don't file an answer, the applicant can proceed against you without you having the opportunity to participate in the hearings at all because you didn't file your documentation. So if we are talking about an application that involves children, remember I keep saying that in Canada and in Ontario, the legislation has been specifically tweaked to say that the courts must, at every stage of the process and what is going on, to figure out what is in the best interest of the children. So in Ontario, if an application is commenced that includes parenting claims, then both the applicant and the respondent are required to complete a mandatory information for parents session, or a MIP, which is the
Mm.
mandatory information for parents.
Mhm.
This is a mandatory 2-hour information session that explains the processes and laws that relate to separation and divorce. The MIPS will tell people about how a divorce or a separation affects adults emotionally, how a divorce or separation will affect children if there are children involved. It is a very high level overview of the legal issues that you're likely to run into if you are divorcing or separating. It will give you options on how to resolve issues if you and your partner don't agree right off the bat on what you think should be done. And it also gives a high level overview, much like what we're doing now, about how the court process works. So usually anyone who started a family law court case or has a case started against them has to attend the MIP. You don't have to go to a MIP if you're actually doing an order on consent where you've both agreed to everything that's happening. If you had to attend a MIP in the past, or if you're only seeking a divorce or claims relating to family arbitration. So again, so there are some limitations and exceptions, but I wouldn't worry about them because in the majority of cases, you will have to attend a MIP.
Okay.
The court will give each party a date to attend their MIP, after which each party will then receive a certificate to confirm that they attended their MIP, and that's the certificate that also needs to be filed with the court, because under the family law rules, completion of the mandatory information for parents is a mandatory step. Okay?
Oh,
So
sorry, can I just ask a quick
people,
question?
an application,
Very quick question. The MIP, did you say that? So if you don't have parenting claims, then you don't have to attend MIPS? Like, let's say that you're only suing for property, so there are no
nope,
MIPS?
you still have to go through the MIP.
Oh, you still have to go through the MIP. Okay, got it.
Yep, you still go through the MIP.
Okay.
Again, we were talking about if all you're asking for is a divorce,
Yeah.
you don't have to go to the MIP.
I see.
But if you have property issues, if you have support issues, if you have kid-related issues, you got to go to a MIP unless you've gone to a MIP before,
Right.
because it's like a canned presentation. MIPS.
Yeah.
I actually do. I'm the lawyer presenter on
Right.
MIPS for the local mediation service provider in our region.
Yeah.
So I do a lot of these MIPS, but basically, unless you've been to a MIP before,
Yeah.
Most of the time you will be required to attend a MIP. If you
Okay.
don't think you have to, it's something that you need to check in with your court office because they will tell you whether in fact you need it or not.
All
Okay.
right. Sounds good. Okay.
Okay, so the MIP is a mandatory requirement. It's part of the process. You have to complete it on this roadmap. It's one of your first pit stops along the way.
Mm.
So to go back to what we said earlier about when the application is being issued, the application, if it's in the Ontario Court of Justice or the Unified Family Court, will actually have a first appearance date put in, which will advise the respondent that the first appearance date in this matter is X date at X time. Okay, that date is noted on the first page of that application if you're in an OCJ, Ontario Court of Justice, or UFC matter.
Mhm.
Okay, now the first appearance is your actual first court appearance because the MIP happens online. It's a video presentation, and there's a chance to an opportunity to ask questions. So I always say the MIP is a really good opportunity to ask questions too about general information. You can't get specific legal advice, but it's a good starting place to start getting information.
Right.